thing.
Yes.
So let us start the function. Am I audible?
Yes.
Hello?
Yes, 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 yes.
Yes, sir.
Audible, audible.
Yes, audible,
Thank-
very much
thank you,
audible.
Thank you, thank you.
Yeah, audible, sir.
One request, please mute all other participants whenever you want to speak. Of course, at that time we can unmute. Otherwise, then the guest speaks will be problem. So with your request, I welcome you all. Shri Vikas Sanjan Bhattacharya, MP, our beloved president, respected Dr. N.K.Jayakumar, former Vice Chancellor of New Ireland National University for Advanced Legal Studies, our chief guest, today's chief guest, all other leaders, activists, well-wishers of Ailu, all viewers of this program, and my dear friends, colleagues. We assemble on this platform to pay our tribute to our great founder, secretary, general secretary of All India Lawyers Union, great Hardev Singh. We know from the very inception of our organization in 1982, for almost 30 years, he guided us with a clear vision and he was instrumental in the propagation and the campaign for a national judicial commission, an autonomous, independent institution with a constitutional status for selection and appointment of judges to constitutional courts, that is high courts and Supreme Court. Of course, with fair representation for all stakeholders and with the comprehensive powers. We know at that time, initially, there were no takers for the idea. But great General Secretary Hardev Singh could outreach all sections of the people, all sections of the society. As convener of Committee for Judicial Accountability, he could outreach judges, former judges, juries, mainstream lawyers, other intellectuals, academics, and after some time, the idea is generally accepted by the society. Now we know the society in general has accepted the idea or relevance of National Judicial Account Committee. And what should be the representation? What should be the constitution? What should be the powers? Of course, in detail, there may be different opinion, but generally people now accept the idea of an independent, autonomous institution with a constitutional status for selection and appointment of judges to the constitutional courts, that is high courts and Supreme Court, not only for selection and appointment, but also for transfer and also with the power to inquire into their misdemeanor. So I can say this itself is a great tribute to our founder General Secretary Hardev Singh. And today, we assembled here to pay tribute the situation, the political situation in India. We know that India is passing through the darkest period after independence. The period of onslaught on independence, onslaught on democracy, onslaught on freedom of expression, personal liberties, civic rights, and of course, an ecosystem of a surveillance society is being created in macro and micro level. In such a situation, I'm happy and I feel honored that one of the finest academic jurists of India, Dr. N.K.Jayakumar, is here to deliver Hardev Singh first memorial lecture, and the subject is of seminal importance. To challenge new challenges to freedom of expression and the idea now being projected by the present regime in office with respect to nationalism, nationality, and of course, secularism and democracy. His erudite opinion would definitely enlighten us to sharpen our fight against the onslaught on democracy, and definitely it would help in our fight or our campaign to protect our constitution and democracy. So I wholeheartedly welcome Dr. N.K.Jayakumar to this function. I wholeheartedly welcome our president to this function. I welcome all other leaders, activists, all other viewers, my dear friends and colleagues, to this function. Now, dear friends, I don't want to waste precious time because we are eagerly waiting for hearing Dr. N.K.Jayakumar. I request our President Vikas Ranjan Bhattacharya to speak few words as presidential address. Vikas-ji.
Yes, good evening. I welcome you all, especially welcome to our key speaker today, Professor Jayakumar. We will be deliberating on various issues which have very importance in the present society and which has definitely have some nexus with the activities which was originated by our beloved leader, Comrade Hardev Singh. His memorial lecture will be applied. We can throw light and organize lawyers, particularly to ensure the freedom of expression and freedom of thought and dignity of person, which is one of the fundamental concepts of the Indian Constitution. In the present time, we have been noticing for last few years that the most affected zone is the concept of dignity of persons. Now here, a young boy, a thirsty young boy could be killed mercilessly because he had the courage to take water from the upper class people. We have seen how the basic human rights of the women are ravished when a rape convict is given freedom by the executive authorities, and not only that, they are welcome to society, claiming to be the Brahmins, and the Brahmins have the right to ravish a woman of, according to them, of the lower quality. This is a situation which requires us to honor about the constitutional rights and the protection of constitutional morality. And I'm happy that Professor Jayakumar is here and he will definitely enlighten all these areas. With these few words, I once again request Dr. Jayakumar to speak on this subject, and I pay my personal respect to him. Thank you.
Sir, I request Dr. Jayakumar. Sir, your mic is muted, sir.
Yes. Sri Vikash Ranjan Bhattacharya, President of the All India Lawyers Union, Advocate Surendranath, General Secretary of All India Lawyers Union, other organizers, participants in this discussion. I must thank Advocate Surendranath for the generous words of introduction he has given about me. In fact, when Advocate Surendranath contacted me and made a request that I must deliver the first Hardev Singh Memorial Lecture, and I accepted that invitation and immediately suggested a subject which came to my mind. A little later, when I started reading on the subject, thinking on the subject, I found it very complex. And apart from the ideological and technological dimensions which I initially proposed to discuss, there are many other dimensions which are equally important. Of course, in the course of a lecture like this, I cannot explore all the possibilities. And some of my thoughts are tentative and may not convince those who are listening to me. But I promise you that I will make a thorough revision of what I present today. And as I understand, All India Lawyers Union will publish the lecture either in popular English or in some other form. For that, I will definitely revise, make it more systematic and convincing. Now, since this is a lecture which pays homage to the memory of Hardev Singh, it is only in the fitness of things that I make a few observations about Advocate Hardev Singh. Of course, I cannot claim that Advocate Hardev Singh was a friend of mine, but I had an occasion to meet him once during a national conference at the Ailu in Delhi, the early 80s. I don't remember the exact year, but it was the 1980s. Soon after the formation of the All India Lawyers Union. And I had the opportunity to discuss with him a few things about how he conceives the idea of an organization like Ailu. He was very clear about it. He told me that he wanted it to be a platform for lawyers, law teachers, and law students. Not merely lawyers, even though the title is Lawyers Union. And he told me that the very idea of lawyer encompasses those who are in the law teaching profession as well as students who aspire to be lawyers. I don't know how far the dream or the vision of Hardev Singh has been realized in the organizational pattern of AILU, but the present leaders can definitely think about this vision and how to translate that vision into a reality. What I found remarkable about the life and work of Hardev Singh is his dedication to a cause, commitment to a cause. I felt that if Hardev Singh had adopted a different path in his profession, he would definitely have become one of the richest lawyers in the country. Such was his caliber. With sound education received from the United Kingdom, very good background, family background. His father functioned as Chief Justice of Pepsu High Court. And his foresight in espousing the cause of judicial accountability, when everybody was speaking about judicial independence. That's a remarkable thing about Hardev Singh. He had a vision. He understood the real problem of Indian judiciary is not that of independence, but that of accountability, which is even today, I must say, lacking in the Indian judiciary. Whenever I address lawyers or law students, I used to say, repeatedly say, that the Supreme Court of India is the most powerful court in the world. And then I add, sarcastically, but the least accountable. There are many instances to illustrate what I said just now, but since that's not the topic for today's lecture, I don't want to dwell on that. The fact that I am speaking to honor the memory of Hardev Singh makes me a little nervous because of the anxiety. What extent I would be able to do justice to the task that has been assigned to me by the All India Lawyers Union. The topic, as all of you know, is new challenges to freedom of speech and expression, ideological and technological dimensions. Because impulsively, I thought the major challenges to freedom of speech arise today from two angles. One is ideological, because free speech is always related to ideology. Free speech is a political concept. Freedom of speech is a political right. Viewed from that angle, ideological dimension is very significant in order to understand freedom of speech, as well as in understanding the threats, challenges faced by freedom of speech. Whenever we use the word freedom of speech, speech in that context is not merely what we utter, our words, the words we utter, but it always includes conduct. Conduct as a form of expression. You hold a demonstration. Even a silent demonstration without any slogan shouting or anything vocal, anything expressed in words will definitely deserve the protection of Article 19(1)(a). Today, I will not go to a conventional definition or examination of the way in which this right has been interpreted by our courts, even though that is very important. But my focus will be on some of the challenges, especially concentrating on, as the title indicates, technological and ideological challenges. If you trace the origin of freedom of speech and expression, it goes back to the period of Socrates, who was a martyr for the cause of free speech. We all know how Socrates met with his death. He was a martyr for the cause of free speech. Cardoso, one of the most well-known judges of the American Supreme Court, said, freedom of speech and expression is the matrix on which all other liberties are founded. It is called the mother of all other liberties. It is accepted universally as a basic human right. We are a democracy, and democracy is accepted as one of the basic features of the Constitution of India. It is now a part of the preamble. Our republic is described as sovereign, socialist, democratic, secular republic. How can we make democracy really meaningful? Unless free speech is given a constitutional guarantee, we cannot have a meaningful democracy. In order to make our democracy meaningful, we have to ensure participation in the political process. And only through freedom of speech, we can ensure such a participation. Now, after 52 years of the Indian Constitution, we turn back and look at Article 19(1)(a), freedom of speech and expression. We all know that the philosophy of freedom of speech and expression is articulated in the preamble itself. And it was one of the ideals which inspired our freedom movement. The colonial era witnessed curtailment of freedom of speech. And our national leaders, our national movement was very much concerned about restoration of the freedom as they started work on drafting a new constitution for the newly emerged Republic of India. But if you analyze the debates in the Constituent Assembly, surprisingly, we find two streams of thought in conflict with each other. There were members who considered free speech as a subversive right and argued for restrictions. Their focus was not on the right, but on restrictions. For example, a member, Rajeshwar Prasad, said, when free speech was the matter of discussion in the Constitutional Assembly, he emphasized on the role of restrictions. And he said restrictions are necessary in national interest. But there are many others. As a typical example, I take Hardev Singh man, who said that freedom of speech and expression is the very life of civil liberty. He said, I would have myself preferred if these rights were granted to our people without restrictions which have been imposed. So he was in favor of an absolute right to freedom of speech, which of course is only a dream. No system in the world has guaranteed an absolute right to freedom of speech. During the initial years of the Constitution, the question of free speech has come to the Supreme Court in various forms. And one of the questions which the Supreme Court of India had to consider in the initial years was the validity of some acts like Public Safety Act in Punjab and a similar act, Maintenance of Public Order Act in Madras. In Ramesh Thapar, a very important case as far as freedom of speech is concerned, the Supreme Court invalidated this particular act, Public Safety Act, because the words used as justifications for imposing restrictions on freedom of speech were very vague and capable of being interpreted in a manner which will restrict, unnecessarily, unduly restrict freedom of speech. In those days, the word sedition was not there in Article 19, and public order as a ground for restricting freedom of speech was not in the provision. Ramesh Thapar was a communist leader and the editor of a magazine called Crossroads, which criticized the policies of the government of India, especially Jawaharlal Nehru. This was the reason why he was prosecuted under the Public Safety Act. And the very constitutionality of the act was challenged. And the Supreme Court of India, in a monumental decision in Ramesh Thapar, invalidated the act. So the lobby in the Congress party, which was always arguing, right from the Constituent Assembly, they were arguing for more and more restrictions on this particular fundamental right. They gained a new voice. And again, they started lobbying for imposing more restrictions, which resulted ultimately in the First Amendment Act. Very interestingly, when the Americans speak about First Amendment, they mean the amendment which was introduced in the American Constitution in order to protect freedom of speech. But unfortunately, our First Amendment is a law, an amendment to the Constitution of India, which effectively took away a substantial part of freedom of speech and expression. Commenting on the First Amendment, the famous historian Ramachandra Guha makes the following observation. From the perspective of free speech, the amendment was regrettable as it resurrected colonial laws which the Constitution of India sought to remove and allowed the government a great deal of leeway in suppressing dissent and criticism without leaving the courts with much room to protect it. This is the crucial point. How can a democracy survive without a right to criticize and right to dissent? And along with the right to criticize and right to dissent, a citizen must also have the right to protest. Because without protest, criticism and dissent will be meaningless. So, free speech is a guaranteed fundamental right precisely because in the absence of criticism, in the absence of dissent, in the absence of protest, a democracy cannot survive. Democracy is sustained only through criticism and dissent. By using very vague terminology like public order and other grounds which have been introduced in the Constitution by the First Amendment, the spirit of Article 19(1)(a), freedom of speech and expression, has been substantially diluted. The use of words like public order as a ground for imposing restrictions on free speech makes judicial intervention in cases of abuse rather difficult. Moreover, the ambiguity instills a sense of fear in the minds of citizens. This is also very crucial because as restrictions increase, as ambiguity in the provision increases, there's a fear in the minds of the people. If I say that, will I be penalized for that? So I keep a sort of self-restraint, self-censoring, because I don't know whether what I say will amount to or will be entitled to the protection of Article 19(1)(a), freedom of speech and expression, or is it likely that I may be penalized for what I say? Freedom and rights of an individual can be used to mark the status of a nation and how it treats its citizens. These rights give the citizens a sense of liberty in which freedom of speech and expression is considered to be the topmost liberty in the hierarchy. The freedom to express can have different justifications, and the most crucial one is that freedom of speech and expression provides the citizens a sense of engagement in the political issues and also some contribution in the smooth working of a democracy. Justice Krishnaiyer observes, this freedom is essential because the sensorial power lies in the people over and against the government, and not in the government over and against the people. This is a very important jurisprudential debate which has been going on and still going on. One of the leading thinkers of the present times, Sunstein, rejects the conventional thinking that the First Amendment standing for freedom of speech and expression. First Amendment is primarily a shield that protects speakers from government censorship. Sunstein rejects this notion, and he considers the First Amendment as a sword that the government must use to fight for ideals of deliberative democracy. Sunstein suggests that
నేనా?
There's some intervention. Somebody's line is interfering. Can you hear me now? Yes, sir.
Yes, sir. Yes, sir. We are
Ah,
here.
yes. Yes. Okay.
Yes, yes, yes.
Okay. I was referring to the views of a very important thinker of our times, Cass Sunstein. There was two streams of thought about freedom of speech and expression, and Sunstein is one of those philosophers who think that freedom of speech is not something which protects citizens from government censorship, but on the other hand, it is a sword that government must use to fight for ideals of deliberative democracy. He suggests that government controls the quality of information in society so that citizens will become more informed and therefore virtuous. Is there any interference now? No. The First Amendment then constitutionally requires the government to promote greater attention to public issues and ensure greater diversity of views. So this is a weapon, an instrument in the hands of the government, so that government can shape public opinion, government can channelize public opinion, and government always decides what is in public interest and what the people should say, what should be the terms of the debate. There is a contrary view which has been popularized by great persons like Justice Holmes and Justice Branches. Of course, I don't want to explain that now, but it will be a part of the text which I will be handing over to Surendranath after my lecture. Courts also have taken to irreconcilable approaches towards freedom of speech. First is the liberal individualist view that understands freedom of speech to be central both to individual autonomy and political democracy. Views restrictions upon speech with great suspicion, disallows restrictions that are designed to block ideas simply on the basis of the offense or distaste they might cause, and narrowly interprets restrictive laws such as defamation or obscenity. So this is one approach which the judiciary adopt. Opposed to this is the paternalist view, which tends to understand free speech as an annoyance or as an impediment to communal harmony, to public morals, or security. The paternalist approach allows the state wide leeway to ban or censor speech that might be deemed dangerous and subversive, and treats offense as a valid ground for restricting free speech. Ever since the Constitution of India came into force, these two traditions have been in tension with each other. So it is a basic question. What is the philosophical approach of the court to questions of free speech and restrictions on freedom of speech? Whether it is a liberal individualist view that the judge is following, or the paternalist view, which is more inclined towards upholding restrictions on free speech rather than enlarging, expanding the contours of free speech. The American courts have generally viewed any restriction on freedom of speech as prima facie unconstitutional. They start with the presumption that it is unconstitutional and then go to the merits of the case. Because the inclination of the judiciary towards upholding, adding new dimensions to freedom of speech is very, very prominent in the American Supreme Court's approach to freedom of speech. One of the recent books on freedom of speech in India has been written by Abhinav Chandrachud. Abhinav Chandrachud is a younger brother of Justice Dhananjay Chandrachud, who is likely to be the next Chief Justice of India. And Abhinav, a book titled The Republic of Rhetoric. He concludes that India's cultural norms, not its constitution, which determines the contours of free speech. So it is not the constitutional terminology or the interpretation of the judiciary of this constitutional terminology that ultimately determines free speech, contours of free speech, but India's cultural norms. Partly agreeing with Abhinav Chandrachud, I would add that the political ecosystem, what kind of political architecture that we have in India is crucial in determining what are the contours of freedom of speech. Because freedom of speech has two important dimensions. One is protecting what I have to say, whether it is right or wrong. My right to speak out, express my views is very important. That's why a famous French philosopher said, I do not agree with you, but I will defend with my last drop of blood your right to say that. So upholding the right of a person to express his view, whether that view is acceptable to you or not. That is the essence of freedom of speech. And unless you have a political climate in which this right, whether you like it or not, this person has a right to express his views. This person or a group of persons, so long as it does not amount to clear incitement to violence. See, in Kedarnath and other cases, the Supreme Court itself has categorically said, you can question anything. You can advocate toppling a government. It is very easy to call it subversive speech, but even a speech of subversive nature is okay, provided it does not incite people to immediate violence. This incitement to violence must be immediate, proximate. Unless that proximity is there, it is meaningless, it is irrational, it is unconstitutional to prohibit such speech. So, while Abhinav Chandrachud places cultural norms as the focal point of evaluating freedom of speech, I would also add the political climate, the political factors as decisive in determining what exactly is free speech as it obtains in India. Unfortunately, the overall approach of the, especially the Supreme Court, to protecting freedom of speech has not been very praiseworthy, admirable. But there are cases like Shreya Singhal, 2015, Shreya Singhal, in which the Supreme Court struck down Section 66A of the Information Technology Act, where the government invoked public order in Article 19(2), which was subsequently added by the First Amendment. But the court did not accept the contention and came to the conclusion that the words used are so broad and vague that they inevitably exercise a chilling effect upon freedom of speech and expression. For a restriction to be reasonable, of course, every restriction on a right under Article 19 must be reasonable. It has to pass the test of reasonableness. To be reasonable, the offending speech must rise to the level of incitement. Everything short of that, including advocacy of subversive and even revolutionary views, was permitted by the Constitution. These are the words of the Supreme Court. These observations do not amount to a new exposition of law by the Supreme Court, but they are drawn from a 1960 decision of the Supreme Court in Ram Manohar Lohia's case. Ram Manohar Lohia, as we all know, was a great socialist leader. Now, the disappointing part of Shreya Singhal is that it upheld the constitutional validity of Section 69 of the Information Technology Act. I will have to say a little more about Section 69 when I speak about controls on social media and the internet. In India, freedom of the press is also a part of freedom of speech and expression. We have not specifically guaranteed freedom of the press, as they have done in the American Constitution. So whenever we speak of freedom of speech and expression, we also have in mind the freedom of the press. I don't want to speak at length on freedom of the press record of protecting freedom of the press. In the recently published Index of Press Freedom, India's rank is 150 among 180 countries over the world. It was 142 last year, but this year it has further dropped and reached 150 out of 180. Now, one concept which has been discussed recently in so many platforms and hotly debated is sedition. Sedition, as you all know, is a colonial legacy embodied in Section 124A of the Indian Penal Code. Sedition acts as a major restraining factor on freedom of speech and expression, and it is being used and unused, abused, misused a number of times. The United Kingdom, they have abolished the offense of sedition in 2010. And of course, it was impossible to retain sedition as an offense in UK because UK has adopted the European Convention on Human Rights. And these two cannot survive together. So they had to repeal. But they had contributed sedition to the Indian legal system, which still survives and is being utilized. There are many countries in the world where the offense of sedition is there in the statute book, but it is never put into practice. The recent abuse of sedition law can be gathered from the fact that the conviction rate for this offense was 33.3% in 2016, and it came down to 3.3% in 2019, which means that nearly 97% of the cases under this provision for the offense of sedition, the prosecution has not been able to prove any offense, and the accused person had to be acquitted. The Supreme Court of India in Kedarnath versus State of Bihar put a limit on the scope of Section 194A. Now, it is again being reconsidered by Supreme Court, but even the observation or the dictum of the Supreme Court in Kedarnath has not been followed. Even today, the instances of abuse of this provision are rampant. Only in rare instances, the courts intervene in favor of the accused, as in the case of Vinod Dua, as the Union of India. Supreme Court upheld the journalistic freedom of Vinod Dua and said that every journalist is entitled to protection and the sedition law has to be applied as provided in Kedarnath judgment. Some of you may remember that this case was initiated by a BJP leader in Himachal Pradesh, who filed an FIR against Vinod Dua for criticizing the Prime Minister and the government of India on his YouTube channel. The court intervened and quashed the first information report. Now, similar is the case of criminal defamation as a restriction on freedom of speech. That's a topic on which I don't want to discuss further, but I will come to hate speech. Hate speech is a current topic. Hate speech is not a specific offense in Indian law, but there are many countries which are thinking about making hate speech an offense. In India also, this has been considered by the Law Commission of India when they have recommended two provisions: insertion of Article 153C and 505A. What is hate speech? An Indian academician who is well known all over the world, Piku Parekh, describes hate speech as speech which views members of the target group as an enemy within, refuses to accept them as legitimate and equal members of society, lowers their social standing, and subverts the very basis of a shared life. It creates barriers of mistrust and hostility between individuals and groups, plants fears, obstructs normal relations, and exercises a corrosive influence on the conduct of collective life. Going by this definition of hate speech, we can immediately see that a lot of hate speech is being propagated against groups, identifiable groups. But the complex question is, if we create hate speech as an offense, what will happen is, with what is called the selective enforcement of the law that we practice now in India, that we find in India today, those who are charged with hate speech will be the wrong persons. The real hate speech, the perpetrators of real hate speech will go undetected and unpunished. So there are valid grounds for imposing a restriction on freedom of speech on the ground of hate speech, but there is a potential for misuse. And we must clearly understand how much misuse is likely to take place before we argue in favor of a law which penalizes hate speech. Now, social media is now influencing the communications between people. Some of the studies show that internet connections in India has reached a level which is more than the United States of America. And the penetration of the internet and the influence that social media produces, the impact that it makes is great, unimaginable. The diversification is a matter which has great democratic potential. But the danger is that it facilitates spreading misinformation and wrong propaganda. Even educated people are prone to manipulative propaganda orchestrated online. Because we know people, see, even our friends will say, this is what I found in a particular website or in WhatsApp, some message which I received in Facebook. So these are all taken as true. People do not verify whether it is fake news or disinformation. They just believe it. Or when a number of orchestrated attempts are made, they have a tendency to believe what is stated. Now, this is what we can call digital politics. Digital politics which can be used as a fertile ground for manipulating public opinion. Manipulating public opinion is a distortion of democracy. The real democracy is lost, and in its place, a distortion of democracy takes place. To maintain ethical boundaries and to ensure that campaigns, online campaign techniques, do not violate privacy of citizens. It is a real challenge. Increasing instances of social media have been identified during communal violence. Democratic potential of the internet and social media is definitely very significant. And powerful actors with access to state resources are getting more and more powerful by driving away voices of marginalized groups, activists, and ordinary citizens. This is really happening. And there is also an unholy nexus or alliance between what we now call big tech, Google, Microsoft. See, people who have the control of technology. Internet, social media are technologically controlled by a few. And when those who control the digital platforms, they collude with those who have political power. It's a very dangerous combination. And this dangerous combination will sound the death knell of democracy. It will not merely amount to a distortion of democracy, but it is capable of destroying democracy. That's the danger of digital politics. Now, how the government interferes with social media and the internet is a very interesting question. About internet shutdowns. We have the experience in Kashmir. India ranks first. At least in certain things we have rank 1. And one thing in which India can claim rank 1 is internet shutdown. India is even called the internet shutdown capital of the world because 67% of total internet shutdowns around the world in 2018 took place in India. Imagine the situation. In 2018, internet shutdowns in India amounted to 67% of the documented cases of internet shutdown. In 2020, Supreme Court in Anuradha Pasim case laid down very important conditions to be satisfied by the government to suspend the internet in an area. Court was hearing petitions on the internet shutdown in Jammu and Kashmir following the repeal of Article 370. The internet shutdown, which was started on August 4, 2019, earned the dubious distinction as the longest internet shutdown in the world. It lasted for 6 months initially, and some of the restrictions continued for 18 months. The Supreme Court, rejecting the secrecy claims of the government, directed publication of orders recognizing that without them, the litigants would not be able to seek judicial remedy. A direction was issued to conduct periodic review of shutdown every 7 days. This may sound to be very attractive propositions, but do you know who conducts a review? See, it is the proposal is initiated by a bureaucrat. It goes up to the Secretary, Information and Broadcasting Ministry. Shutdown order is issued. Then this review mechanism, which is stated to be one of the safeguards, is again by 3 persons picked from the bureaucracy, who neither have independence nor claim any impartiality. So, what the Supreme Court says about periodic review of shutdown every 7 days is a meaningless safeguard. The procedural safeguards as well as the statutory safeguards have proved to be illusory. So another category of restrictions which is gradually emerging in the world scenario is disinformation. Can disinformation claim the protection of freedom of speech? Article 19(1)(a). Disinformation is, of course, it has dangerous overtones. And everybody may agree that disinformation has to be curtailed. Disinformation has been defined by the European Union Code of Practice as virtually false or misleading information that is created, presented, and disseminated for economic gain or to intentionally deceive the public and may cause public harm. Some of the disinformation that is propagated may be harmless, but some others are very harmful, very injurious to public interest. Disinformation covers deliberately spreading false news, marketing products using false information, distributing altered content. In some contexts, it may also include blended information, some false and some true. So, fake news is a subcategory of disinformation. Many countries have already adopted measures. Countries like France, Singapore, Malaysia, Canada. But here again, the question that arises is it wise? Is it advisable to add more and more categories of restrictions to freedom of speech? What will be the ultimate effect of these restrictions? Just imagine that we add a further category of disinformation to the grounds which are enumerated now in the Constitution as grounds for imposing restrictions on free speech. How do you define disinformation? Can we arrive at a foolproof definition which is relevant and meaningful in the Indian context? How that definition is going to be interpreted by the judiciary who have to apply the restrictions, decide on the constitutionality or validity of the restrictions. So many questions will arise, and how the administrative machinery is going to use the law that has been enacted. These are all very complex questions that are likely to arise, and when we think of disinformation as a problem to be addressed, we must definitely think of the impact that such a law will make on our right to freedom of speech and expression. The combination of new technology regarding expression and the elasticity of free speech rules do not provide any answers to the legality of government attempts to regulate the internet. Some of the dangers are there, like use of social media platforms by wrongdoers to cultivate hatred and negative stereotypes against vulnerable groups, and the use of the platform by many different organizations and people to confuse and mislead the public on important questions of public policy. Now, a latest statement by the Ministry of Information gives us an idea about how this power is being used. On the orders of the Information and Broadcasting Ministry, 45 videos from 10 YouTube channels were blocked. This is the latest figure, present figure, for allegedly containing hate speech against religious communities under the potential to cause communal disharmony. It has been estimated that the blocked videos had a cumulative viewership of more than 1.3 crore. The ministry stated that some of the videos in question were being used to spread disinformation. So disinformation and hate speech were used as grounds. Even in the absence of a law, that is what I am pinpointing. A government ministry of the government of India is taking action. Acting under the so-called powers or the imaginary powers that they have derived from rules which are supposed to be made under Section 69 of the Information Technology Act. Last month, in August 2022, the ministry, INB ministry, blocked 7 Indian and 1 Pakistan-based YouTube news channel on charge of spreading disinformation pertaining to India's national security, foreign relations, and public order. See, the real issue, the crux of the matter is, it is not what appears to be on the record. In fact, in actual practice, these powers are used not only to prevent propaganda of hate and communally sensitive material, but to curtail spread of information on issues which the government considers sensitive. So following this doctrine, any reference to Kashmir, any reference to Agnipath scheme, and so many other things, which the government considers sensitive and the government considers any discussion or any propagation of ideas dangerous to their own survival, practically. So this really amounts to a very serious encroachment on internet freedom. And because technology is advancing at a faster pace than legal technologies, technology of law, finding out a solution to these problems is a real challenge. We cannot pretend that the social media's influence is negligible. We have to accept its existence, terrifying presence in our midst, great impact. We cannot pretend that the internet does not exist, or by internet shutdown, we can shut down this forever. So, how do we reconcile the phenomenal growth of technology and social media and internet? The way in which people communicate, the way in which people interact, this is changing very fast. already changed and is undergoing changes. Opening our eyes to the reality of the situation, how do we reconcile our fundamental right to freedom of speech and expression with advancing technology? While welcoming advancing technology, suppose we are allowing more and more restrictions on freedom of speech and expression, then it will be a Himalayan blunder that we may be committing. But can we close our doors to the technological advancements so that we remain anachronistic? No, we have to make use of the advantages that technology provides. How do we use technology in furtherance of democratic values? How do we use technology in furtherance of constitutional values? This is a crucial question that we face. And I would definitely conclude by saying that it is a challenging task for the All India Lawyers Union to explore these questions in depth. That's a crucial thing, in depth, not superficially. And if my words act as a stimulant, or if my words provoke you to some action, follow up, I will feel rewarded in my endeavor. And I would also feel that I have done justice to the memory of the founder, General Secretary, Advocate Hardev Singh. Remembering Hardev Singh again, who is a person who has impressed me. In just one meeting, he has impressed me, and his image, his personality, his vision is embedded in my thoughts. I thank the organizers once again for giving me the opportunity to make this speech in memory of Hardev Singh. And I apologize to you if I have not gone up to your expectations. After seeing the subject, many people have different expectations, I know. But if I disappointed you, I promise you that I will make some more additions to the tentative lecture which I have prepared now. And it will reach you through one of the Ailu platforms. That is what I believe. That is what Mr. Advocate Surendranath will definitely take care of. Thank you once again. Thank you for patiently listening to my words.
Thank you, sir. Thank you. Shri Rajendra Prasad ji.
Yes. Thank you, sir. Today the subject, new challenges of freedom of speech and expression, is very apt. And you rightly put it, how the marginalized peoples are throttling and the government is misusing the 124A IPC, that is sedition law, and also OPA Act. And we are also we are aware that the Supreme Court time and again has been recognizing that dissent is as a vibrant democratic symbol, because we have to use the new technology and how to protect the freedom of speech by using new technology also, as rightly you put it. And anyway, we are on behalf of All India Lawyers Union, I am very thankful to you, sir, for your valuable speech and your sparing time in spite of your busy schedule. And I also thank all my colleagues who participate in the meeting. And thank you again, sir. And I conclude this meeting. Thank you, sir.
Thank you. Thank
Uh,
you.
I declare this session